Subscribe to our channel and hit the bell icon so that you know when live we go. Hello and welcome to Daily News Simplified. In the next half an hour, we are going to run through today's newspaper, The Hindu Delhi edition, and we are going to discuss the most important articles for civil service examination. The articles that we will be taking up for discussion has been tabulated in front of you, and the time stamping for the same has been given in the description section. There is an article on page number 9, Attorney General denies plea against Swara. This plea was the plea to initiate the criminal contempt case in the Supreme Court against the actress Swara Bhaskar. So this article is related to criminal contempt proceedings in the court. There is another article on the same page, Supreme Court overreacted in the Bhushan case. The Bhushan case was also a criminal contempt case. Both these articles are related to criminal contempt matter, so we are going to combine both of them and have one holistic discussion. See, the thing is, section 15, which you don't have to remember, of Contempt of Court Act 1971 talks about cognizance of criminal contempt. But the details of the initiation of the criminal contempt has been given in the rules to regulate proceedings for contempt of the Supreme Court 1975. And section 3 of this rule lays down the conditions as to when the contempt case can be initiated. It says, in case of contempt other than contempt referred to in Rule 2. In the Rule 2, contempt during the proceeding of the court has been talked about. In such case, the court in which the proceeding was going on, that particular court will have the power to punish the contemptor. But if the contempt has happened outside the court, then in those cases, the contempt proceeding can be initiated in 3 ways. Either the court take the suo motu action, the judges themselves take the cognizance of the issue, or a petition is filed by Attorney General or Solicitor General. Or it can be initiated in a third way. It can be initiated on a petition made by any person. But the only condition is, if the person is trying to initiate a criminal contempt against another person, then he or she needs to have consent in writing from Attorney General of India or the Solicitor General. So, a petitioner wanted to initiate criminal contempt case against the actress Swara Bhaskar. So, for that purpose, she needed the consent in writing of Attorney General or the Solicitor General. So, the news is that Attorney General has declined the plea against Swara Bhaskar. Attorney General has declined to give a written consent. But the petitioner has said that she respectfully disagrees with the opinion of the Attorney General and now she'll be proceeding to Solicitor General because both of them can give the permission. But if the top law officer of the Government of India has declined, it is very less likely that the Solicitor General will give the permission. But by law, there is no such foundation on Solicitor General. He can have a different opinion than Attorney General. Whatever the case would be, we will come to know in the coming days. But before we proceed ahead with the present discussion, it will be worthwhile to understand the difference between civil contempt and criminal contempt. Because we have learned here that if a petitioner wants to initiate a criminal contempt against another person, in that case, he or she needs a written permission from Attorney General or Solicitor General. This differentiation of civil contempt or the criminal contempt comes from Contempt of Court Act 1971. They have not been defined in the Constitution of India. Section 2A of Contempt of Court Act 1971 defines civil contempt and criminal contempt. Civil contempt simply refers to the willful disobedience of any order of any court. But the criminal contempt includes any action or publication by a person which will scandalize the court, which will present prejudice against any judicial proceeding, or which will interfere with the administration or justice in any other manner. As you can see, the definition is very vague and open-ended. So it will be subjected to the interpretation of the court. And it is very subjective whether a particular action of a person, a statement or any publication scandalizes the court. Scandalize means to speak falsely or maliciously about any person or institution. It also means to brutalize the moral standing of any institution. Basically, if we say in Hindi, it means लालछन लगाना, गलत इल्जाम लगाना, कीचड़ उछालना. In that sense, the meaning of this word is taken. But what will scandalize the court, what will not, that is very subjective. But however, now we have understood from where the definition of criminal contempt and the civil contempt comes, and we also have seen their basic definition. Now let me explain to you a basic legal question that has been raised in the article. See, we have understood if you want to file a petition against another person concerning criminal contempt, you have to take written permission from Attorney General or the Solicitor General. And during the proceedings of Prashant Bhushan case, this legal question was raised by the advocate of Mr. Prashant Bhushan that the petitioner has not taken the written permission of Attorney General. But the court took the case as suo motu. And we know that the court can take suo motu actions for criminal contempt. But what does suo motu mean? Suo motu generally means the action taken by the court by itself. But surely the action of the court will be based on some source of information. Either the newspaper reports or information from the social media that the judges themselves pick or any other source. Supreme Court said that the source of information could also be a petition. Suppose a petitioner goes with a petition with some set of documents and judges get to read it. So that could also be a source of information for the judges, and based on that information, suo motu action can be taken. But the former Attorney General of India and the celebrated jurist Soli Sorabji has disagreed with this opinion of the court. Soli Sorabji has said that Attorney General is the first law officer. The court cannot ignore him. The inherent power on the court to initiate the contempt that comes from Article 129 is subjected to certain limitations. And bypassing Attorney General is the misuse of this inherent power. See, if you can turn the petition into a suo motu action, then the third condition of initiating the petition will effectively be null and void. Because now you are not needed to take the permission of Attorney General. You can simply go to the court to file the petition, and that petition can become the source of information for the judges, and based on that, the judges can take suo motu action. Then there is no meaning of this condition applied in the Rules to Regulate Proceedings for Contempt of Supreme Court 1975. Soli Sorabji is saying that Article 129 does give power to Supreme Court to punish against its contempt. But the manner and the way in which the punishment will come about, that comes from Contempt of Court Act 1971. And the rules to be followed, that is given in the Rules to Regulate Proceedings for Contempt of Supreme Court 1975. So to use this article in an absolute sense, disregarding the rules that has been laid out already, that will be violation of the inherent power that the courts enjoys from the Constitution. But still you will not form an opinion on this. Supreme Court has said that the case of Prashant Bhushan can be turned into suo motu case. Soli Sorabji is having a different opinion. What opinion will you have? You will always have opinion of the Supreme Court for the civil service examination. And you should wait for a final legal hearing on this matter by the Supreme Court itself. But you should be aware of this legal question that is being raised with regard to the criminal contempt. Criminal contempt has been in news too much, and that makes this topic very important for the coming mains exam. So you have to understand this from different perspective. Now we come down to the reason as to why Attorney General has declined to give a written consent. Attorney General has shown great restraint and statesmanship in this case. He has given some reason, and those reasons becomes very important for you to know. You can use them in the mains answer. Attorney General has said that the part of the statement of Swara Bhaskar appears to be factual, and part of the statement seems to be perception of the speaker. And this one is very important. Take a strong note of this. Attorney General has said that the comments refer to the judgment of the Supreme Court and is not an attack on the institution itself. So it cannot be considered scandalous. Meaning that you can criticize individual judgments of Supreme Court, you can have a particular perception about it, you can air your view, but there is a boundary of that. You cannot attack the institution itself. That will amount to being scandalous. Attorney General has said that the concerned comment is not on the Supreme Court itself or say anything that would scandalize or lower the authority of the Supreme Court. Attorney General has said that one of the statement is vague and is not related to any particular court, and something so general that no one would take any serious note of this statement. Now, suppose a question has been asked in the mains exam like this. What is your opinion on the legal jurisprudence concerning criminal contempt against the court in India? Do you think it needs to be modified? Then in writing the answer to this question, somewhere you will mention that if the comment against the court is factual, there is no problem. If it is an individual perception of the speaker, then also there is no problem. If the comment is against a particular judgment of Supreme Court and not an attack on the institution itself, then also there is no problem. Now we will come to the opinion of Soli Sorabji concerning the matter of Prashant Bhushan contempt case. Soli Sorabji has given a very balanced opinion, and I will highly recommend you to take note of that because that can form your opinion in the final mains exam. Soli Sorabji has said certain things. Let me first take you through this and then I'll give you his opinion in the form of an answer. He has said that Supreme Court has overreacted by taking suo motu contempt proceeding against Mr. Bhushan. Soli Sorabji is of the opinion that the court could have lectured Prashant Bhushan, could have warned him, but the court should not get serious about punishing him. He says that people have different beliefs. Do you punish people for having some belief which are not of the liking of Supreme Court? Soli Sorabji says a very interesting thing. If Mr. Bhushan is ready to establish the fact of his allegations, then how can you prevent him? He should not be intimidated into silence. Of course, if his allegations are baseless, frivolous, then punish him. But do not punish him before giving him a chance of presenting his case. Do not punish him just for saying it. The opinion of Soli Sorabji is beautiful and it can become your opinion concerning the matter of criminal contempt in your mains answer. See, judiciary is an important institution, no doubt, and its dignity cannot be undermined. However, there is a question of principle, of whether one has right to criticize the judiciary based on certain facts or definite facts or not. Every citizen has the right of his independent view. If somebody says judges are corrupt, allow him the opportunity to prove his allegation right. Judges are human, they can be corrupt. If he or she is found to be completely scandalous, then punish him or her, but not before that. One cannot be punished without giving a chance to prove his allegation. The authority and dignity of Supreme Court as an institution will be enhanced if it addresses the allegation, rather than to impose contempt on the person who made them on basis of facts. So all in all, a chance to present your case must be given. You must be allowed to prove your allegation. Punishment cannot be given just for raising questions. There is a lead article on page number 6, More Evidence of India's Food Insecurity. This article has been written in the context of State of Food Security and Nutrition in the World 2020 report. This report is considered to be the most authoritative evaluation of hunger and food insecurity in the world. It is released by United Nations. Mostly Food and Agriculture Organization takes the lead in this, but is done in collaboration with other UN institutions like International Fund for Agricultural Development, UNICEF, World Food Programme, and WHO. This is extremely important report that you have to prepare a short notes on for the coming mains exam. Because in the syllabus of GS paper 2, there's a topic mentioned poverty and hunger issues. And UPSC does not miss a year to ask question on this particular subtopic of GS paper 2. For example, last year UPSC asked this question. There is growing divergence in the relationship between poverty and hunger in India. The shrinking of social expenditure by government is forcing the poor to spend more on non-food essential items, squeezing their food budget. Then in 2018, UPSC asked another question on cause of hunger, whether that is because of lack of availability of food or because of ineffective human development policies. Then in 2017 too, they have asked a question, hunger and poverty are the biggest challenges for good governance in India still today. And then you were asked to evaluate the performance of successive governments with regard to this humongous problem. So it's a very important topic and you must know what's there in this report. The broader aspect of food security and nutrition in the World Report 2020 has been already covered in the DNS dated 28th July 2020. It was covered by Naveed sir. So we will not deal with the report broadly, but today we are going to have an India-centric discussion. First of all, you must know few basic things. State of Food Security and Nutrition in the World report since 2017 is coming up with two parameters to measure food insecurity. One of that is prevalence of undernourishment. Prevalence of undernourishment focuses on estimating the proportion of population facing chronic deficiency of calories. Deficiency of calories means you are not getting enough energy to do day-to-day work. That signifies non-availability of even starch-based food like rice. And prevalence of undernourishment is measured mostly through consumption data. This consumption data is provided by the respective national government to the UN. But apart from prevalence of undernourishment, since 2017, the report is coming up with another parameter called as prevalence of moderate and severe food insecurity. And this is more comprehensive in its nature. It not only measures calorie deficiency, but it also measures access to adequate and nutritious food, availability of protein, availability of vitamins. And this is done not by consumption data, but this is done rather by a direct annual survey. People are asked questions like, do you have to downgrade your diets from rich, complete, nutritious food to just starch-based food, and question like that. So it is more direct in nature and this is more reliable. And this survey is done by the UN institutions in different countries. But the catch is, in order to publish the data of the survey, Food and Agricultural Organization has to take permission from the national government. And permission has not been granted by India to publish the data regarding prevalence of moderate and severe food insecurity. So direct data regarding this is not available. But in a roundabout manner, the data is available. Because the report gives two kinds of data, one of South Asia and one of South Asia minus India. So comparing these two data, one can estimate, as the author has given in the article, the condition of India. So these two factors becomes an important measures for you to know and use them in your answer regarding hunger. These two are also globally accepted to measure the progress of Sustainable Development Target 2.1, which is to end hunger and food insecurity. SDG Goal 2 is regarding hunger, and 2.1 specifically is regarding access to nutritious food. There is one more thing that has been highlighted by the author in the article, that the NSSO Consumption Expenditure Survey of 2017-18 has not been released by Government of India for some reason. As a result of which, the conventional measure of poverty and food consumption are not available. And what is the conventional measure? Conventional measure is this, prevalence of undernourishment, which is measured by consumption data, which is gathered by national government. But we don't know of this data because National Government of India has not released it. So in that case, we have to rely on prevalence of moderate and severe food insecurity data of Food and Agriculture Organization. The data concerning India from the State of Food Security and Nutrition in the World 2020 report are as follows. India accounted for 22% of global burden of food insecurity, and this is the highest for any country. The report of 2020 actually has gathered data from 2017-19. So everything is prior to COVID-19 pandemic. Situation after and during COVID-19 pandemic will be even worse. The report also has highlighted that the prevalence of food insecurity increased by 3.8% in last 5 years. It has increased in India, but it has fell by 0.5% in rest of South Asia. And this is something that you will have to explain. The report has estimated that 31.6% of India's population suffered from moderate to severe food insecurity. So these are some of the things that you must keep ready in your hand for the mains exam. There is another related index that you can use in your answer, which is Global Hunger Index. Global Hunger Index is released by International Food Policy Research Institute in collaboration with Concern Worldwide and Wealth Hunger Health. You have to specifically remember for the exam that India ranked 102nd out of 117 qualifying countries in 2019 Global Hunger Index. You might also use a comparison that among BRICS grouping, India's rank is the worst. Within South Asia too, India is behind every other country. Sri Lanka, Nepal, Bangladesh, and surprisingly Pakistan all are ahead of India. If you see this global hunger index mapping, the countries which are in grey, they have not been included because these countries are high income countries, and the purpose of the index is to measure the progress towards achieving SDG goal 2. These countries are already supposed to have achieved the goal, so they are not included here. The countries in green are doing well. The countries in light green are also doing okay. But countries in yellow have serious hunger issues that include India, Pakistan, Afghanistan, Bangladesh, and many African nations. And countries with orange color, as you can see, have problem of hunger even more alarming. That includes Yemen, Syria, Madagascar, Chad, Zambia. The country in dark red has extremely high alarming rate of hunger. And this country is Central African Republic. What is going on here? Why this is in dark red in the map? But we have to know that the condition of India is very poor. It is poorer than China, Russia, even the Central Asian countries, even the Middle East countries, even Myanmar, even Vietnam. So the obvious question to be asked is, why the position of India regarding hunger is so poor? First of all, there is systemic problem of lower per capita income. Then there is another systemic problem of agrarian crisis. Majority of the employment is in agriculture, and agriculture has become non-remunerative to the extent it is difficult to survive through employment in agriculture. In the recent time, because of falling investment in various sectors, there is problem of employment generation. In fact, the periodic labor force survey has shown that unemployment rates in the recent years have been higher than last 4 decades. According to the Center for Monitoring Indian Economy, the unemployment rate in India in 2019 was 23.3%. And after COVID-19, it will shoot up to 32.5%. And you can see the countries doing better than India in hunger index also have lower unemployment rate. Then it is also widely believed that during demonetization and after introduction of goods and services tax, many faced economic distress and hence faced moderate to severe food insecurity. But as we have mentioned before, all these data are prior to COVID-19 pandemic. And because of COVID-19 pandemic and sudden imposition of an unprecedented and prolonged lockdown, there will be increased problem of hunger and food insecurity. There has been sudden loss of livelihood. In the previous DNS of 20th August, we have seen that in the informal sector, the loss of employment during the month of April was 91.3%. Although the sector has recovered, and in the month of July, the loss of employment was 6.8%. But the loss of employment for 4 months is hard to be recovered. And vast majority of India's poor are facing increased threat of food insecurity, hunger, even starvation. We have heard many cases of starvation to death during COVID-19 pandemic. Even before pandemic, India's per capita consumption of protein, meat, poultry, fruit, vegetable was already low. In fact, lowest in the world because of low purchasing capacity. But after pandemic, there will be increased problem of food access. Food will be available, but people will not have sufficient income to get access to the food. And hence, the author is suggesting that the prevalence of moderate and severe food insecurity data of the UN report provide an important baseline to estimate for the situation before the COVID-19 pandemic. But it becomes extremely important to conduct a national survey on food insecurity to assess the impact of COVID-19 pandemic and the present prevailing situation. Because the fear is that situation must have gone worse by now. There is a news article on page number 10, not possible to fully block Chinese firms. After the intrusion of Chinese military into our territory, there has been outrage against Chinese, and there has been demand to ban Chinese applications, Chinese firms. Government has already banned 59 Chinese applications, and government also has cancelled many of the bids that were already in the process to be given to Chinese firms. But since the economy of India is so much integrated with Chinese, India is finding it difficult to fully ban Chinese firms. And this was dealt in detail in the DNS dated 19th June. Can India decouple itself from Chinese manufacturing? It was discussed by our illustrious magical Vaibhav sir. So we will not take up this economic aspect of difficulty in decoupling with China. But here we are more going to talk about the security aspect. So the question now in hand is this. Are we going to ban Chinese firms because of outrage and negative sentiment building against Chinese, especially after their intrusion into our territory? Or there are some inherent merits in banning the Chinese firms? In other words, do Chinese firms poses a security threat? The intelligence assessment of India and also worldwide has cautioned that direct and indirect link with many Chinese companies, that there are direct and indirect links of People's Liberation Army of China with many Chinese companies. In fact, in 2017, China passed a national intelligence law which gave China power over Chinese companies working overseas. And the security threat to other nations stemmed from this particular legislation, because this legislation required Chinese company to fully provide full assistance and cooperation to China's national intelligence work wherever those companies are operating. Article 7 of this law states, any organization or citizen shall support, assist and cooperate with the state intelligence work in accordance with the law. And that is why FDI coming from China is now seen with lots of caution. In India too, we have presence of Chinese giant. For example, ex-India Steels Limited. This is by far the largest joint venture between India and China. The main investor in this venture is Chinese Xinjiang Cathay International Group, and they have commissioned palletization facility of worth 250 crore. Xinjiang Cathay International Group actually has been reconstructed from institutions of General Logistic Department of PLA. So allegedly it is directly linked with PLA. Same goes with Huawei. The founder of Huawei has been associated with PLA since 1987. Although now he is not, but in 1977 he was PLA's engineering corps. And this is one of the major pretexts why Huawei is seen as national security threat and has been banned in many countries including US and UK. The issue of Huawei and the global ban on Huawei was dealt in detail in the DNS dated 13th of August 2020, again discussed by our magical illustrious Vaibhav sir. In this DNS, you were told about many instances where Huawei was seen involved in compromising other nations' security. Some of those instances you have to keep on your fingertips. Then other companies like CETC, which manufacture military electronics and CCTV cameras, they also have presence in India. In 2018, CETC announced $46 million investment in 200 megawatt photovoltaic manufacturing unit in Andhra Pradesh. But this company has been implicated by US Department of Justice at least 3 times for illegal export, and in fact many employees have been convicted for military espionage. So huge presence of these companies obviously poses security threat to India. Chinese has been investing in India's startup to a great extent. For example, in Zomato by Alibaba, in Swiggy, in Ola, Paytm, Flipkart, BigBasket, Dream11, Oya, Udaan, Byju's. And this is one way of integrating Indian economy with the Chinese economy. Previously, in the DNS dated 20th August 2020, I discussed with you the strategy of Chinese to integrate the economy of other countries into their own. The Silk Route project of China has the same global aim. Chinese has done this with US. Chinese have invested hugely in the bond market of US. We discussed in context of Russia too. Chinese are wanting to integrate the gas and oil pipeline of Russia, which is the artery of Russian economy, with Chinese. China has done that already with India, and that is why we are finding it difficult to fully ban Chinese firms. And if this goes unabated, maybe a time will come when it will be impossible to ban Chinese companies because we will be dependent on them. So it's not the matter of simple public outrage. You need to know these solid reasons to check on Chinese firms' investment in India. There is a news on page number 5, Balaghat women curb felling of trees. This news can be used as a case study in 15 marker for the environment section of GS paper 3. It can also be used in essay paper. For many years now, there has been indiscriminate felling of trees in the Balaghat district of Madhya Pradesh, and this has rendered acres of fertile land barren. Then the local women of the adjoining villages came together and they formed a group for vigilance against deforestation. They, with lathis in their hand, chase away those who are felling trees and impose a fine on them. There has been imposition of fine of rupees 500 for anyone who is seen carrying an axe. This local women group has taken the ownership of local forest. For any conservation, we know very well, local ownership is very important. Conservation of any natural resource, be it forest, be it lake, be it anything, cannot be done without involvement of local people. And this has yielded result. Around 250 acres of land in the district is now seeing revival, with the forest officials planting saplings and the women group protecting them. It also has been pointed out in the article that since women are tasked with venturing into the forest to fetch the fuel wood, women organized into groups are better placed for this surveillance job. And also in the process of vigilance, they can sustainably use the resources of the forest, they can pick the fruits and the medicinal plants judiciously. This also has given opportunity to women to take up the leadership role. It has made them more aware of environmentalism. So the benefits are plenty. Now only one question I have to ask in this. What do you think about imposing a fine of rupees 500 for anyone who is carrying an axe? Is this illegal? Can this be done at the local level? The question formally is this: if the panchayat of the village wants, can such a rule be made? And if yes, under which provision of the constitution? Now I will ask some few simple questions. It will be easy for you to answer because I will ask only from within what we have discussed so far. The first question is this: Supreme Court in the Prakash Singh case directed the state and the center to bring police reform. Suppose if a state has not brought any reform and violated the order of the apex court, then can any person file the contempt case without the consent of Attorney General? Yes or no? Think about it. It will be a prize that you will give to yourself if you can answer this correctly. Well, the correct answer is yes, it can be done. Why? Because the permission of Attorney General is required in case of criminal contempt. It is not required in case of civil contempt. And willful disobedience of any order of any court is civil contempt. So if Supreme Court directed to do police reform and if the Chief Minister has not done it, then he is liable for civil contempt, and you don't require AG's permission in case of civil contempt, so you can go and file the contempt. This in fact was done by late Ram Jethmalani, but nothing was done. In this case, the court's hands were really tied. Most of the state did not do the police reform. So the contempt proceeding cannot be initiated against almost all the Chief Ministers of India. Next question is, which article of the Constitution of India gives Supreme Court the inherent power to punish for its contempt? It is article number 129. As per article 129, Supreme Court will be a court of record and shall have all the powers of such a court, including the power to punish for contempt of itself. So the inherent power of punishing for its contempt is derived by article 129. The third question for you is this: the office of Attorney General is a constitutional office. True or false? Of course it's true. Attorney General of India is appointed by the President of India under article 76(1), and he holds office during the pleasure of President. The office of Attorney General is a constitutional office. The office of Solicitor General, is that a constitutional office? No. To assist the Attorney General, there is a position for Solicitor General. And to assist Solicitor General, there are additional Solicitor Generals. And their office and their duties are governed by Law Officers Condition of Services Rules 1987 and not by Constitution of India. Now pay attention to this. The terms civil contempt and criminal contempt are not defined in the Constitution. They are only mentioned once. Is this statement true or false? This statement is a false one. These terms are neither defined nor mentioned in the Constitution. The Constitution of India talks about contempt. Their bifurcation into civil contempt and criminal contempt has been done by Contempt of Court Act 1971. The next question is this. The State of Food Security and Nutrition in the World Report 2020 has been released by Food and Agricultural Organization in collaboration with International Food Policy Research Institute. True or false? Well, this statement is false because it is indeed released by Food and Agriculture Organization but in collaboration with other UN bodies and not in collaboration with International Food Policy Research Institute. The report is released by FAO in collaboration with International Fund for Agricultural Development, UNICEF, World Food Programme and WHO. International Food Policy Research Institute in fact comes out with Global Hunger Index, which is also very important for the exam. Then the last question for you is this. Among the BRICS grouping, India is ranked the worst in Global Hunger Index. And unfortunately, the answer is true. The question of last DNS was, arrange the following rivers from north to south. Mahanadi, Godavari, Kaveri, Krishna. It's an easy one. The order is Mahanadi, Godavari, Krishna and then Kaveri. So answer is option C. Question for today is this. Which of the following constitutional articles provide inherent power to the courts for punishing against the contempt? Article 142, 129, 130 or 131. Thank you very much for hearing me out and do attempt the DNS quiz.